Now, Mr. Biskin, we've got to finish at 4 o'clock this afternoon.
Yes.
We can't sit on beyond, so I'm afraid I'm going to have to ask you to complete your opening submissions by 11 o'clock.
Right. Then I'd better get on as quickly as I can. My Lords, first of all, just in an effort to deal with the questions about antecedent powers raised yesterday, that is antecedent prior to the 2000 Act, and also in relation to the symmetry of powers that your Lordships raised with me yesterday, I have produced a little bundle, or 2 bundles, one of which is the index to the Financial Services Act 1986, and then some of the relevant provisions, not all of them, in a second bundle for ease of reference. I've kept them separate so I could look at both at the same time. Can I just make the following remarks? It's also quite useful to have open, for these purposes, tab 16, which is the delegation order 942 of 1987, at page 217. And in particular, the transfer of functions articles 3, 4, 5, and 6, which your Lordships can see refer in Article 3 to Section 114 as being transferred under 4 to a designated agency subject to a reservation. 5, the functions under Section 178, which are investigation powers. And then the function of the Secretary of State under Article 6 under Section 199, which are again powers of entry with the assistance for justice of the peace, a warrant. And what I want to simply say, my Lords, is this, that the Financial Services Act, of course, was designed in part to regulate investment business for the very first time. It created a general prohibition on anyone carrying on as such. And that prohibition is found in Section 3, which is before your Lordships in the second bundle. All of this is contained within Part 1 of the Act. It provided for the regulation of this business to be in the hands of various SROs who might grant authorizations to individual organizations and indeed professional bodies, such as the Law Society and so forth. It also provided for authorizations by the Secretary of State, that is sections around about 34. The Act exempted in 35 to 36 a number of important persons, namely the Bank of England, recognised investment exchanges, money market institutions, and the Corporation of Lloyds. Under sections 47 to 63, it made provision for the conduct of investment business and for rules to be made and their publication, very importantly, that's sections 47 to 63. It created certain powers of intervention under 64. It dealt with authorised collective investment schemes such as unit trusts and powers of intervention under 75 to 95. And it created the Financial Services Tribunal, section 96 to 100. Information powers were granted, in particular those at 105 and 106, and those are set out on pages 7 and 8 of the little bundle, the second bundle, which were not, save in limited circumstances, applicable to the exempt persons, and permitted the Secretary of State to authorise an officer of in some contexts, a competent person to exercise the information requests that he might make. There are Chapter 12, which contains Section 114, transferred the functions or provided for the power to transfer the functions of the Secretary of State to a designated agency under Section 114 and 118, and allowed the powers to be resumed, if necessary, by the Secretary of State. Chapter 14, Sections 119 onwards dealt with restricted practices, and Part 2 of the Act dealt with the application of the investment business provisions to insurance companies, Part 3 with friendly societies, Part 4 with official listing of securities, Part 5 with offers of unlisted securities, and so forth, Part 6 with takeovers, and Part 8 with insider dealing. Those are the sections at 173 to 178. In particular, the powers in relation to the same was found at pages 14, 15, and 16, and 17 to 19. So under section 177, the Secretary of State had powers to appoint competent inspectors to carry out investigations. That was under 177. And to report to him. Those powers were not delegated. Under 178, there were penalties for failure to cooperate with 177 investigations, and certain powers under those were delegated to the designated agency. In particular, those powers set out at 178 subsection 3, which empowered the Financial Services Authority in substitution of the Secretary of State to serve notices and so forth and so on. They were essentially regulatory powers, my Lord. They were not powers to institute proceedings for insider dealing offences. Those were delegated. Similarly, under section 199, on pages 20 and 21, there was a provision for powers of entry under warrant. And 199 is the empowering section. The Justice of the Peace may issue a warrant under this section if satisfied information on oath that there are reasonable grounds for believing that either certain statutory offences have been committed or this one offence outside the statute under Part 5 of the Criminal Justice Act, insider dealing, had been committed. And various powers were delegated by virtue of subsection 7 of that. But if one goes to the regulation, the order in tab 16 and Article 6, the function of the Secretary of State under section 199 is transferred where it's exercisable by virtue of 1991A in any case in which the offence or one of the offences an offence under 4 or 57.3, or where it's exercisable by virtue of 1991B in any case in which the requirement referred to in that enactment is one which has been imposed by the designated agency or a person authorised under section 106 of the Act. So you have to go back to 106 of the Act, and you see that what that is concerned with is the regulated business only. And our simple submission is that, of course, what section 402 does is that it widens powers. It's a dramatically and different section, one which you don't find within the Act, of the earlier Act at all. And it confers power, it allows the authority to institute proceedings. And we submit, if one looks at the overall structure of the FSA in 1986 by comparison with the 2000 Act, you see that the structure of powers and so forth is completely and utterly different. Moreover, my lords, if one looks at the schedules, which are again in the Schedule 7 and Schedule 9, we may not have covered everything, but these are set out in the second bundle at 23 and 30. Our principal submission is that where the authority was under an obligation to publish under the legislative powers codes of practice and so forth as to how it was going to exercise its functions, and it had to seek the permission of the Secretary of State. If one, for example, goes to Schedule 9, paragraph 4 on page 33, a designated agency shall send to the Secretary of State a copy of any statements, etc., made by virtue of the functions transferred to it by a delegation order, and give him written notice of any amendment or revocation of or addition to any such rules or regulations, and it shall send a copy to the Secretary of State. It had to, and furthermore, oops, I'm so sorry. At page 41, under paragraph 12 of the same, where a designated agent, this is page 41, where a designated agent proposes in the exercise of powers to make any statements of principle, rules, regulations, or codes of practice, it should publish the proposed instrument in such manner as appears best calculated to bring the proposals to the attention of the public, together with the statement that representations about the proposals, etc., can be made to the agency within a specified time. And it made no such publications. So, if you take that, my lord, take the structure of the Act, and the then Memorandum and Articles of Association to be found in tab 2 of Millennium Friends, tab 2 of volume of Millennium Friends supplementary volume, white volume, the objects of the company are set out in paragraph 3, capital A, on the first page behind that tab. The essential objects are to...
So which page is that?
It doesn't have a page number, Lord. It's in the white bundle, and it's behind tab 2.
I beg your pardon.
That's one, Lord, there. And it's the 4th page behind that.
Thank you.
And this is the original Memorandum Arts.
This is what?
Memorandum of Articles of Association, my
Did you
lord.
say original?
Not the original one, but one which was in force, I think, immediately
2000,
before the
April
Act,
2000.
before FISMA, yes. Sorry. And you can see, my lords, that it was the subject of its objects was the regulated industry. And over the page under Roman numeral 2, without prejudice to the generality of paragraph 1, to do anything with a view to arising in connection with the transfer of the company or all of any its functions to which section 114 applies. And so forth.
Page what you just read from?
I'm so sorry, it's tab 2.
Yeah.
Your Lordship has the first page of the Mem and Arts, page 1 at the bottom, then page 2 at the bottom,
Yeah.
and Roman numeral 2,
Yeah.
without prejudice to the generality of paragraph 1.
Yeah.
To do anything with a view to arising in connection with the transfer of the company of all or any of the functions to which section 114 of the FSA 86 applies.
Yeah.
So, my lord,
You showed us the 1987 delegation order.
Yes.
Was there any other delegation order?
well, there are other delegation orders, my lord, but I'm not sure that I'm in a position to say that they materially apply anything at all. I've done my
Are
best.
there any other relevant?
I don't believe so, no.
So as far as...
There may be minor matters, but I've done my best to give a synoptic view of the powers of the FSA.
Just putting it shortly, do I understand your position to be, in broad terms, that Schedule 3 contains all the offences with respect to which power to institute proceedings have been transferred by the Secretary of State?
By the Secretary of State, yes. Not under the Banking Act, which came later, as we know, in 1998.
Yes.
But by the Secretary of State. Now, I may be wrong. The Financial Services Authority, frankly, is far better position to tell your Lordship precisely what its powers were antecedent the Act than I am. But
are you saying that the power to prosecute is outside the Memorandum and Articles?
the power to prosecute is provided for in Schedule 3 to the order.
I'm just asking about the Memorandum and Articles at the moment.
Yes.
They're wide enough to include a power to prosecute, are they? A, if a statute provides it, and B, I suppose if it doesn't.
Well,
just looking at the Memorandum and Articles.
yes, my Lord, candidly, I'm not an expert in this field of law, and I wouldn't wish to profess any expert opinion about this matter, but I would respectfully say that the power is conferred by the order, and that the order provides for the prosecution of offences which are there to enhance its role as a regulator in accordance with the functions conferred upon it by the by the Secretary of State.
Yes, well, Article 3b, little 6 on page 3 of the memorandum does give some power to institute legal proceedings.
Yes. Thank you, Lord. Yes, yes.
That's the one the Court of Appeal referred to.
Yes.
Yes, thank you.
Thank you, Lord. So it's my submission, Lord, that Section 402 is doing something entirely different and throws the ambit of the prosecution offences wider than simply people within the regulated industry.
So I thought the point of your reference to 2 little a, Roman 2 little a, on page 2 was that was where you were, which referred to the functions which have been transferred, and also then to any other investing in company powers, functions pursuant to any other law or any regulation, this being the articles as in existence when they knew that the new Act was going to be coming into force later in the year.
Yes. Yes, Lord.
Yes. So, I mean, frankly, B6, I mean, may be right, but I mean, it looks much more as though it's to deal with civil proceedings, but that may be just be an unduly narrow view of the matter.
Yes. Anyway, what I respectfully submit is that Section 402 is doing something different. There is a symmetry of investigation powers with the offences either bespoken by the Act itself or spoken to. That's the Part 5, 1993 legislation. And that one has to look at Section 402 in the context of the Financial Services Act 1986, which, of course, was entirely repealed.
Entirely what?
Repealed. Now, given the time, my Lord, I think your Lordship will have in mind, may I just first of all say, I can find my case. Where's my case? May I first of all just, going back to the case itself, my Lord, behind tab 3. On page 4, wherever it's been written by me, there was an intention and belief on behalf of the Treasury. Should be substituted. I'm corrected by Mr. Perry quite rightly about this in his case. I should have said that the principal purpose of the section is identified by wherever I've said there was an intention and belief on the part of the Treasury in 1.7a, b and c. That would be in accordance with what Lord Justice Brooke said in the case of Flora and Wacom. Lord, I'm going to, again, given the time, the deeming provisions issue, which is a complex one, we submit that Section 1 of FISMA confers a complete suite of functions and it therefore represents a complete statutory code. And it appears that every relevant act passed after the statute, FISMA, has a deeming provision in it which incorporates the powers in that act under FISMA. We give various examples. My learned friend Mr. Perry relies on the earlier acts, the Mutual Societies Acts, but those are all antecedent to or prior to the 2000 Act. He doesn't cite an example of something that occurs after. The Financial Services Authority has notably not said what these deeming provisions are actually for, if they're for anything else than ensuring that the powers conferred by those later acts, in fact, are brought within the purview of the 2000 Act itself.
Terry, sorry, did you say deeming provision?
Deeming, yes.
Which is the deeming provision we're looking at?
My Lord, well, there are various ones. There's in tab 11, it's tab 11, section 15.2 of the Insolvency Act 2000. Tab 12.
Well, wait a minute, just a...
I'm so sorry, my Lord.
You don't
Yes.
need to look at them all, just...
Yes. Tab 11.
I see. 15.2, yeah.
15.2. Then tab 12, page 178. Part 38 of Schedule 11. Poker.
So where in 12 was that?
It's page 178 if my notes are correct. At the foot.
Yeah.
At tab 14, page 209, we've looked at this. This is in the Counter-Terrorism Act. Otherwise, I rely on the contents of the case. I've set out in detail with my learned friend Mr. Rose in section 7 the various submissions that we have in relation to the details of section 402 and why the Court of Appeal got it wrong. We respectfully submit. In point 8, it's a very simple point, namely that section 380, which is the definition of a relevant requirement under part 25 of FISMA, speaks of a power to prosecute and is concerned with such and not overcoming a restriction on its power to prosecute. I would agree that paragraph 8.4 of the case was incorrect. The fallacy of consequences argument in point 9, little to add save that which is in the written case. There's no need for a conspiracy power. Because this is under A, the substantive insider dealing offence may be committed by encouraging another. That's a point which is letter A. And the rest of the offences in relation to the Money Laundering Regulations and Counter-Terrorism Act concerns non-compliance with specific regulatory requirements. And there's currently no need for any conspiracy power in relation to those, outside what could be a straightforward joint enterprise. Yes. Well, yes. And there are submissions in relation to the use of the word generally, which the Court of Appeal placed reliance on. That's under point 4, my Lord. And we respectfully submit that the Court of Appeal misidentified the use to which generally was put, and that one has to refer back to the Banking Act 2009 and to the section 249, 1 to 3, so that one can identify what the meaning of the word generally is.
I'm really lost at the moment. Where is it? Where are you concerned?
I'm so sorry, my Lord. This is point 4 of our case on page 6. And if you go to it's tab 15, page 214. It's 249 of the Banking Act 2009, which was inserted into section 1 of FISMA. In relation to this, it's under the rubric Financial Services Authority, section 249, and under 2494, at the end of Section 1 of the Financial Services Markets Act, the authority add for Section 249 of the Banking Act provides for references to functions of the authority, whether generally or under this Act, to include references to functions conferred on the authority by that Act, subject to any order under that section. We simply say that that is the deeming section, effectively, for the subsections which immediately preceded, and importantly 2492. And it doesn't bear the weight that the Court of Appeal placed upon it. Now, my lords, I'm going to very quickly say something about private prosecutions, if I may.
Does the Act, the FUSMA, does that refer at all to the memorandum and articles of the FSA?
I wouldn't want to swear to that point. I haven't come across it myself. I don't think it does. I look at Malone from Mr. Perry, who's likely to know more about it than I do. No. Just a word or two about private prosecutions. I've little to add to that which was set out in the written case. I just draw your Lordship's attention to this, and I'll cite the authorities, but the laying of informations, broadly speaking, are required to be done by a natural person. This is the effect of Lord Justice Watkins's judgment in the case of Rubin. And I'll set out if one looks at the head note, and paragraph 364D, 365E, and 366G onwards.
Where are we meant to be looking at this case?
Well, my lord, I was going to give you the references. If you want me to take you in detail.
No, I mean, I just...
Yes, of course. It's in the authorities bundle at tab 14.
Tab what?
14. Sorry, my lord. When information was laid in the name of the Thames Valley Police rather than the name of the constable. It's worth reading quite a lot of this, but I'm not going to, given the timing.
But I mean, has anybody ever held that anybody, any legal person, corporate, whatever you like, has not had the power of private prosecution? I mean, we've been referred to lots of cases of the Customs Excise Company,
yes.
various bodies,
Yes.
Lord Mance's judgment in Whalley, the NSPCC, the RS. I mean, has anybody ever been said, terribly sorry, you can't prosecute?
Well, my lord, I think one has to understand what prosecute means. The prosecutor is historically the person who lays the information.
Yes.
In the old days, I don't think you'd do it nowadays, you might also be the person who signed the charge sheet. The effect of what Lord Justin Watkins says is that...
Where is it in your case, this point?
I'm not sure it is, my lord, in detail. But all the cases are there. It's all set out.
So where?
So I'm not sure it's in the case
I mean, I
itself.
can't find a reference to Rubin in the case at the moment. Is there a reference to
Yes,
Rubin
in Malone and Friends.
Not in your case?
Yes, not in my case, but in his case. Yes. Because he deals with the authorities in relation to private prosecution. But if one looks at 364C, the single issue in this appeal to which we have to address ourselves, in my view, is whether information has inevitably been laid by a named person, such as, in the case of a police prosecution, the chief constable himself or any other authorised member of his force. Goes on, there's no statutory definition of an information, that's at E. And then at 365E to G, the laying of information is an administrative act by whoever prosecutes, but the issue of a summons, which is the immediately following process, a judicial act, which can only be performed by a justice of a clerk to the justice. Mr. Alan Jones contends that as well, that a defendant so does a justice clerk to etc. This should be obvious on the face of it. It is also, I believe, equally well established that, generally speaking, any member of the public may lay an information There are statutory exceptions to that right. In some instances, consent to prosecute has to be obtained from a specified authority. But in the vast majority of cases, the member of the public informs, and with rare exceptions, that member of the public is a constable. He reviews the existence of the various statutory powers, and he points to Rule 4.1 of the Magistrates' Court Rule, which has obviously been overtaken by events since then, at 366H. Rule 4.1 of the Magistrates' Court Rules 1981 provides an information may be laid or complaint made by the prosecutor or complainant in person or by his counsel or solicitor or person authorised on his behalf. If someone
What do you
goes...
say we get out of this case as far as...
Well, what I'm saying, my Lord, is if you look at this case, the interpretation of the word person in the context of these rules and subsequent rules does not connote a person other than a natural person, and it disapplies the provisions in the Interpretation Act, because he said at the foot of 368H, I cannot accept that Parliament intended the definition of person in Schedule 1 to the Interpretation Act to apply to the laying of informations. The terms of Rule 4.1 of the Magistrates' Court Rules militate strongly against any other view, in my opinion, etc., etc. Now, although that case was doubted, or Lord Wolfe had some Lord Justice Wolfe had some reservations about that, in a case in which my Lord Savile actually agreed with what Lord Justice Wolfe said in the case of Dixon, which appears in our supplementary bundle. Subsequently, Dixon was consigned to oblivion by the Lord Chief Justice, Lord Wolfe, in a later case called Dixon, which appears in our supplementary bundle and refers to laying charges and so forth and so on. So,
But what was the ratio of Rubin then?
the ratio of Rubin is, on the narrow issue...
Is that an information cannot be laid within the context then applying
Yes.
by the Thames Valley Police area.
That's correct, my Lord. And has to be laid, and informations have to be laid by natural people.
That was a consequence of the provisions which related to the laying of informations.
Yes, my Lord. Now, this case is looked again by Mr. Justice Mitting in the case of Ewing, which you'll find in the same volume, and the case of Gladstone, which is the only
It should have been a
case...
valid information, though, despite that, wasn't it?
It was not invalidated by, no. That was the pragmatic decision, my Lord. Yes.
What is the submission that you're coming to? Is it that only a person, as opposed to a corporate body, can bring a private prosecution?
My Lord,
is that the submission?
What I'm saying is that the only authority my learned friend refers to the powers of body corporate to lay an information is the case of Gladwin, where the point was rather overcome by reference to the fact that it was the solicitor for the corporation who laid the information.
What is the submission that you're making?
What I'm making, Lord, is this, is that it was, I would submit, it was likely to be in the purview of, in the contemplation of the draftsman when he drafted Section 402, that there were difficulties in the way of laying informations by corporate bodies who were not prerogative bodies, such as, or whose powers derived from prerogative powers, such as the revenue and the customs and excise commissioners and so forth and so on.
Well, do you say that a corporate body is incompetent, legally incompetent, to lay an information?
I'm not saying necessarily that it's legally incompetent, but it's a difficult position because if you look at the case of Gladwin, if I would just be very...
Well, I think since time is going by,
Yes.
if I understand your submission correctly, it is that so far as corporate bodies are concerned, the law isn't as clear as it might be, and that is a further indication that the draftsman of Section 402, and come to that 401, was specifying those cases in which the authority could prosecute.
Yes, Lord.
Which is part and parcel of your main argument, which you've now developed at some length, to the effect that if you look at the entire scheme, the message you get from it is that these are the only instances in which the FSA has the power of prosecution.
Yes, my Lord, yes.
Well, that's it, isn't it?
It is, my Lord.
Right or
I would
wrong?
simply, as a footnote, ask anybody interested in this topic to look at Lord Justice Rose's judgment in the case of Gladstone at tab 6 and about the rarity of prosecutions by corporations. The reality is, my Lord, is that when one talks about the RSPCA and so forth, and FACT and so forth, is that they do not themselves lay information. They are officials within them lay the information, and the prosecution is then supported by the society. That's how it's done. It's not a prosecution, therefore, by the body. It's supported by the prosecutor as the person who lays the information.
Well, there we are. Thank you very much.
I'm a little over time.
Yes.
I'm sorry, my Lord. I'm sorry it's taken so long as well to develop
Not
these
at all.
things.
Mr. Ozen, is there anything you wish to add at this stage? No. Thank you. Mr.
Yes,
Perry.
yes, since we arrange ourselves. Do you want both?
No. May it please your lordships, Lords, on behalf of the respondent, may I at the outset make it clear that we adopt the submissions contained in our printed case, and for the purposes of our oral submissions, may I attempt to highlight the essential points in our argument and seek to address some of the questions that your lordships have raised in response to the oral submissions advanced on behalf of the appellant. Lord, may I then, by way of introductory comment, seek to make these points. First of all, in answer to my Lord Brown's question this morning, is there any case which stands as authority for the principle that a particular person, whether legal or natural, may not institute criminal proceedings? The answer to that question is no. There is no such authority, and it would be surprising if there were any such authority, because historically in England and Wales, unlike the position in Scotland with the Lord Advocate, historically the position in England and Wales was that all prosecutions were instituted by legal or natural persons. There was no Director of Public Prosecutions until 1879, and there was no Crown Prosecution Service until 1986. The second observation, by way of introductory comment, is that the answer to the certified question depends on the true construction of Section 401 and Section 402 of the Financial Services and Markets Act, read in the context of the Act considered as a whole. We submit that the position for which we contend has the merit of clarity, certainty, and coherence so far as the criminal law is concerned. And it is not necessary to engage in the sometimes, we would submit, tortuous arguments advanced on behalf of the appellant in order to discern Parliament's intention. Importantly, the appellant cannot demonstrate that the Financial Services Authority could not prosecute offences of insider dealing or money laundering offences prior to the enactment of the Financial Services and Markets Act, which came into force in December in 2001. And, Lords, I'll seek to demonstrate that the true position at that point was that the Financial Services Authority could in fact institute proceedings for those offences, and the position following 2001 was that so far as insider dealing was concerned, whereas prior to December 2001 the authority would have needed to obtain the consent of the Secretary of State or the Director of Public Prosecutions, it was in fact put in a privileged position inasmuch as it could prosecute insider dealing without seeking any consent. That is a recognition of its role as regulator and specialist prosecutor in the sphere of financial services. Set against the background in which the appeal is to be considered is the fact that the Financial Services Authority has classic regulatory powers in that it may make rules, set standards, grant authorities, carry out supervision, and we submit, in addition, it may act as a prosecutor. And we submit that that's hardly surprising, given that the authority as a body corporate with legal personality has the powers that any company limited by guarantee would have. It has the power to institute proceedings for offences whether or not they fall within the Financial Services Act. Lord, may I just deal with the suggestion that was made in the course of oral argument yesterday. The suggestion was made that Parliament has occupied the territory and therefore there is no scope for any ability on the part of the Financial Services Authority to institute proceedings for other offences. And as I understand it, in the course of argument yesterday, it was suggested that support for that position, that Parliament has occupied the territory, could be found in section 401(5), which is the control of the Treasury point, and 402(2), also the Treasury control point. My Lords, may I foreshadow what we say in relation to that before actually taking to your Lordships to the point? Lords, that provision in relation to Treasury control is in fact a legislative technique found in other provisions, and I'll take your Lordships to them, but in particular the Money Laundering Regulations 2003, which could be prosecuted by the Commissioners of Customs and Excise. The Commissioners of Customs and Excise, so far as the Money Laundering Regulations 2003 are concerned, were subject to Treasury control, but it could not seriously be contended that the Commissioners for Customs and Excise only have power to prosecute under the Money Laundering Regulations. What that provision is designed to achieve is supervision by the Treasury in relation to particular matters of sensitivity and parliamentary accountability through Treasury ministers. And in fact, so far as the FSA is concerned, it's all of a piece with the constitution of the FSA. In Schedule 1 of the Financial Services and Markets Act, it has to provide a report, an annual report to the Treasury. The annual report has to be laid before Parliament. The Treasury can appoint its board, it can dismiss members of its board. So, Lord, I'll take you your Lordships to that particular provision in due course. But, my Lord, the essential point is really this. If your Lordships were to conclude that that operated so as to exclude a prosecutorial power, then it wouldn't make sense in the money laundering regulations, because no one suggests that the Commissioners for Customs and Excise only have power to prosecute under those regulations.
I mean, as I understand it, Mr. Perry, from your printed case, really you are invoking this power to exercise Treasury control to give an explanation as to why there is provision to bring certain specific offences within 402.
Yes.
I mean, that actually, as I understand your case, at the end of the day, is really the only logical reason why they have B and C there at all.
Yes. But, my Lord, it doesn't mean, for example, that the FSA can run riot when it comes to prosecuting other offences, because they're still subject to Treasury control under their constitution by reason of Schedule 1 of the Act. But in relation to Section 401 and 402, the Treasury is there able to put in written restrictions or conditions upon which those prosecutions can be brought. In fact, the Treasury has never actually made any restriction.
They have even further powers of control, do they, in relation to this 402 and 401 specified offences?
Not express powers, my Lord, or control, but general powers of control by reason of the Constitution in Schedule 1 of the Act. I'll take your lordships to it in due course, if I may. But Lord, it is right to say that they are specific provisions relating to Treasury control in relation to prosecution for those offences. Lord, another important general point to note at the outset, Lord, and again to foreshadow some of the submissions that I intend to develop, is that the Financial Services Authority, does have the power to prosecute offences which do not fall within the Financial Services and Markets Act. And we've identified a number of statutory provisions that demonstrate that sections 401 and 402 cannot, in fact, provide a comprehensive list of those offences which the FSA is empowered to prosecute. Lord, the argument, as I understand it, that's put against us in relation to that is, well, those provisions predate the Financial Services and Markets Act, and the functions under those provisions have been brought under the umbrella of control of the Financial Service and Markets Act. Well, my Lord, that with respect to the appellant, is simply not right, because there is a provision that I can take your lordships to immediately, if I may, which is in Volume 1 of the statutory materials bundle, behind Divider 22, which is the Payment Services Regulations. And, my lords, may I just try to put this in context? This extract of 2 pages is taken from what would, if your lordships had been provided with the entirety of the regulations, amount to some 82 pages. And the Payment Services Regulations, in summary, just if I may just explain what they do without trying to go into all the ins and outs of it, they implement a directive of the European Parliament to establish an authorisation regime for supervision of payment services if you're not a bank. So, for example, if you're a bureau de change or Western Union sending funds within the European Union, you have to be regulated under these regulations. Your lordships will see from the first page behind Divider 22 that they were made in February 2009 and laid before Parliament on the day that they were made, and they also came into force they were made not under the Financial Services Act, so they don't fall under the Financial Services Act at all. They were made under Section 2, subsection 2 of the European Communities Act 1972. So we are outside the umbrella of the Financial Services and Markets Act in its entirety. And the prosecution of offences is dealt with by Regulation 117, which is on page 320 of this bundle. And your lordships will see that by Regulation 117, proceedings for an offence under these regulations may be instituted only, here's an example of where we have the word only, and then in respect of certain offences by the authority, that's the Financial Services Authority. We don't actually have the definitions section, but if your lordships accept from me, it's the authority, the Financial Services Authority. And then certain other offences in relation to B may be prosecuted by the Office of Fair Trading. Those are, in fact, offences of misleading the Office of Fair Trading in investigations that it has power to prosecute. And then C, by or with the consent of the Director of Public Prosecutions, although by paragraph 2 of Regulation 117, paragraph 1 does not apply to proceedings in Scotland because of the special provision of the Lord Advocate in that jurisdiction. So, my Lords, the simple submission that we make in relation to this is that it is entirely destructive.
Entirely what?
Entirely destructive of the appellant's argument that the Financial Services and Markets Act provides a complete code of offences which the Financial Services Authority is empowered to prosecute, because here is a post-dated enactment, which recognises that the Financial Services Authority has power to institute offences. Now, my Lord, in relation
How does that affect the true construction of Section 401 to 402?
Well, my Lord, the way it affects the construction of those provisions is you can't read 401 and 402 as containing all the offences that the Financial Services Authority is empowered to prosecute, because this is not an empowering provision, because why would it include the Director of Public Prosecutions? You wouldn't need. This isn't an empowering provision. It's a provision that limits. It recognises the authority of the OFT and the Director as privileged prosecutors. It doesn't grant them powers. It's recognising that there is a limited class of prosecutors. Otherwise, there would be no reason to include the Director of Public Prosecutions there, because the Director of Public Prosecutions could, as the Director of Public Prosecutions, prosecute offences. It's just making sure that this is a limited class of prosecutors.
So what is the basis for the prosecution by the authority in this situation?
It's its powers, my Lord, as the authority and a company limited by guarantee, which has all the powers that a company has, including the power to institute legal proceedings.
But you say it's a private prosecution,
yes,
in effect,
yes,
by the company.
Yes.
And the only effect of this is to say that it's one of the people who. And one of the only people is, in fact, the only person who can prosecute for these particular offences, apart from the director. Is that right?
I'm bound to say I wouldn't have guessed that. Just reading it, I'd have thought it created the power.
Well, but Lord...
Unlimited.
Well, but Lord, we say it doesn't. It doesn't create the power. It's recognising that there is a power, because you don't need to create a power on the part of the Director of Public Prosecutions ordinarily to prosecute. What it is doing is recognising that there is a privileged class of prosecutors who also have the power to institute prosecutions for other offences also. But I'll come on to...
Presumably, Mr. Perry, your argument is that absent this provision, private prosecutions could be taken by anyone.
Yes.
But the purpose of this provision is to specify those who may conduct those prosecutions.
Yes. So my Lord, if I wanted to prosecute under these regulations, Western Union, I would have to go to the director and say, please permit me. And he could say yes. This provision wouldn't be granting me the power to prosecute. I would be asserting my right as a private prosecutor with the consent of the director. This isn't saying an individual may prosecute. It's saying, subject to the consent of the director, an individual may not prosecute. So that's the way.
I mean, you couldn't go to the director for one of the A offences, only for the B offences. The A offences can only be instituted by the authority. 117(1)(a).
But Lord, the only... C is saying that proceedings for offences under these regulations may be instituted, and then C is not limited in any way.
I see. Okay.
By or with the consent of the Director of Public Prosecutions. It's not saying the authority is the privileged prosecutor only for some of them, or that the OFT... What Parliament...
I'm sorry, no, I thought C was qualifying only B, but it's both.
I mean, in one sense, you've got the right, because there's nothing in this which gives any power to the Lord Advocate to prosecute, for example. It just assumes that the Lord Advocate can prosecute. And you say the underlying thing is it assumes that anybody can prosecute, and then it cuts back and says only certain people can prosecute.
Yes. I'm very sorry, my Lord. I misheard because I thought your Lordship said you can't be right, but...
No, I'm saying,
Yeah.
I'm saying on this particular matter.
I just want to make sure I'm not... I haven't got a submission I've got to make. But, my Lord, may I try to make good that submission, my Lord, by reference to another statutory provision? Because if your Lordships go to, for example, we've got an earlier provision, tab 4, thank you, of the Building Societies Act. This is, Lord, may I just explain why I'm going to refer to this provision?
Where are we looking?
With tab 4 of the same bundle, my Lord, which contains the provisions of the Building Societies Act 1986. And the purpose of going to this provision, Lord, is simply to make good the submission that legislation does not expressly provide a power to prosecute. It proceeds on the assumption that the power to prosecute exists, which is, if I've understood it correctly, the point being made in relation to the Lord Advocate. And the Lord, here in this statute, if I can tell you, Lordships, this: there is nothing in the Building Societies Act 1986 concerned with these bodies may prosecute for these offences. There's no provision of that sort. But if we look at section 111, which is page 19 of the bundle, which bears the side note time limit for commencing prosecutions, subsection 1 provides, notwithstanding any limitation on the time for the taking of proceedings contained in any act, summary proceedings for any offence under this act may, subject to subsection 2 below, be commenced by the authority, which is the Financial Services Act, authority, at any time within the period of 1 year, beginning with the date on which evidence sufficient in the opinion of the Financial Services Authority to justify a prosecution for the offence comes to its knowledge. And then subsection 2, nothing in subsection 1 above shall authorise the commencement of proceedings for any offence at a time more than 3 years after the date on which the offence was committed. My Lord, may I just explain what this does and how it fits in? If I were to take a private prosecution for a summary offence, the ordinary limit of time for a summary offence is 6 months. That is a time limit imposed by the Magistrates' Courts Act. But this is recognising that the authority in its privileged position as a prosecutor may bring proceedings within the period of 1 year, beginning with the date on which evidence sufficient in the opinion of the authority to justify the prosecution came to light, but it's putting an end cap of 3 years after the date on which the offence was committed. So what this provision is not doing is saying the authority may prosecute. It is recognising that the authority is a prosecutor, but it's giving it special prosecutorial ability. It has the special prosecutorial ability to institute proceedings outside the time limit that would apply to me as a private citizen bringing my criminal proceedings before for a summary offence before a magistrate's court. So there is another classic example of an assumption being made by Parliament that a body has prosecutorial powers. It's not granting the powers, it's recognising the powers, and it's recognising that the prosecutor is in a special position.
These are similar provisions, aren't there, in relation to social security and that kind of thing?
Yes, yes. Your Lordship's absolutely right. For example, trade descriptions, the ordinary time limit is extended for specialist prosecutors.
Mr. Perry, I'm awfully ignorant about how you sort of do things like starting summary proceeding. I mean, it's always laying an information.
Well, the institution of proceedings, my lord, it can be done in a number of ways. It can be by way of information. That's where a magistrate or a district judge issues a summons under Section 1 of the Magistrates' Courts Act.
I know, but how does it, I want to know how a private prosecutor starts a prosecution, and you know the difficulty, if it is a difficulty, in some non-natural person doing it.
Well, my lord, may I just say, the way it happens, my lord, I'll use an ordinary example. I would go along to City of Westminster Magistrates' Court, just round the corner from here. I would be shown into court. I'd go before a Justice of the Peace or a district judge, and I would say I was assaulted by my next-door neighbour yesterday, and I'm now providing you, the district judge, with the information. Will you please now issue a summons? My next-door neighbour lives at the address next to me. Send it to my next-door neighbour with a return date at this court. And having laid the information before the district judge has a discretion to issue a summons, but assume he does, that then institutes the proceedings.
Right. Now, say he wants to bring proceedings for money laundering. Same
Yes.
thing?
Yes, yes.
Now, say he's the RSPCA and he wants to bring proceedings for somebody harming their dog. What's he do?
Same thing.
Same thing. Who does it?
A representative of the RSPCA.
Anybody?
Anybody could do it.
Say a local authority wants to prosecute for noise.
An enforcement officer on behalf of the local authority.
It's an individual who has within the organisation, so to speak, representative powers. Is this it?
Yes. So, my lord, in this case, just so there's no misunderstanding, because the submission that was made to your lordships this morning is a very big submission, if it's going to be suggested, and it was not foreshadowed to us, but it's a very big submission to suggest that a corporate entity does not, in fact, have a power to prosecute. Because clearly a corporate entity does have power to prosecute, and it would be a very serious matter for Parliament to take away the right, whether of a natural person or of a legal person, to institute criminal proceedings. But, my lord, so there's no misunderstanding about it, the summonses in this case were, in fact, sought by an individual acting on behalf of the Financial Services Authority. So to take the Rubin-type position, where the constable seeks the information on behalf of the chief constable, there was an individual of the FSA who went to the magistrate's court and laid the information in relation to this prosecution. There's nothing wrong with that.
I mean, on any view, you have to be able to prosecute those offences for which you alone can
Exactly.
prosecute. So how do you do that? Same way.
The same way.
I mean, it's always an individual, but somebody who is authorised within the body. Is that it?
That's exactly it, my lord. And
so it's no more difficult, so to speak, for an offence for which you claim you're entitled to, as opposed to a privately prosecuted offence.
Do you have the document? Is there a document that
yes,
shows that?
we've got it, my lord. If I may hand it.
Are there any other ways of doing it there?
Well, my lord, I can go through all the ways in which proceedings are instituted in criminal proceedings, because the issue of a summons would be the ordinary way for a regulator. It's the way that the Department of Trade and Industry would have done it when they prosecuted through the Secretary of State. But if I'm
sorry, I'm not really quite clear. Obviously, you've got to have a human being doing it. I mean,
yes.
But unless I mistake the mark, the result of that is what we find on the front of cover of the thing, and that is that it's actually Neil Rollins and the Financial Services Authority. It's not Neil Rollins and Mr. Parkinson.
That's right.
So he's only there as an agent or something like that for the for the Financial Services Authority, isn't it?
Well,
So where's the FSA on the indictment?
well, my lord, on the indictment.
It's just
Well, my lord, may I just explain that? May I just explain the indictment? This is the draft indictment, but I understand that it is in fact the indictment as it has been preferred before the Crown Court and signed. So what I'm saying, the draft should not mislead your lordships. Lord, the convention in England and Wales is that all Crown Court proceedings are brought in the name of the sovereign, and therefore the indictment is framed the Queen against Neil Rollins. It is also the convention, although it doesn't appear to have been followed in this case, but had I been drafting this indictment, I'd have said the Queen on the prosecution of the Financial Services Authority, because the convention would be that you would identify on the face of the indictment the prosecuting authority. It's not being done here. There's no legal impediment to the prosecution being conducted in this way, but that is why by the time you get to the indictment, it becomes a prosecution in the public interest in the name.
So if you were to lose here, you'd simply add on the prosecution of the FSA and the DPP.
Well, ordinarily, the director doesn't ordinarily say on the prosecution of the DPP, but if we were to lose, it would be, yes, I see, yes, to distinguish both, yes. Well, my lord, that brings
So
me
then
to
you'd have the FSA prosecuting counts 1 to 6 and whatever it is, and the DPP prosecuting counts 7 to 10.
Does it matter whether the words go in bracket on the prosecution of the Financial Services Authority or not?
No,
it doesn't matter at all.
But that I just mentioned it, my lord, because that was the convention, and you can still find that in many of the books.
Would it be the same convention for a completely private person? Your example of complaining about your neighbour?
Yes. Yes.
So that would end up with the sovereign's name as the prosecutor?
Yes.
Yes.
Yes. And, my lord,
only if tried on indictment?
usually only if it's tried on indictment, my lord. But, my lord, the first ever public prosecutions were conducted by the Royal Mint. And the first ever public prosecutions were really when it was discovered that prosecutors, you needed to have a professional body of prosecutors to conduct very, very, very special prosecutions. And when there was clipping of the coinage, for example, the Mint had a particular interest in the clipping of coins and wanted to make sure if people were prosecuted for that offence, they wheeled in the big guns to make sure that people weren't getting off on technicalities which bedeviled the criminal law in the 18th and early 19th century. But what we're in danger of in this case is bedeviling the criminal law with another anomaly and absurdity which we submit cannot have been intended by Parliament. And we submit that the absurdity argument is an important matter when considering the intention of Parliament. And, my Lord, we submit that it is no answer to the fact that anomalies and absurdities will arise to say, well, the criminal law does in fact have a number of anomalies and absurdities, because we submit that they should, as my Lord, the Lord Chief Justice observed yesterday, be kept to a very minimum and be avoided if at all possible.
Now, this is the actual information, is it? I mean, it looks almost like a sort of joke, standard thing, flap it this, flap it that, and care of enforcement wholesale, as here on the...
Sorry.
It's almost like a pro forma.
Well, my Lord, it is the information. Perhaps I ought to just deal in answer to my Lord Clark's answer about what other ways can you institute criminal proceedings. Lords, the easiest way to deal with this, my lords, is actually to give your lordships a cross-reference. It's not actually in the materials. But if your lordships want to see how Parliament has dealt with instituting proceedings, in Section 15 of the Prosecution of Offences Act 1985, which Section 15 is not in the bundle, but Section 15 of the Prosecution of Offences Act does contain a definition of when proceedings relating to an offence are instituted, but only for the purposes of Part 1 of that Act. But the various ways are issuing a summons, issuing a warrant for an arrest, when an information has been laid. A public prosecutor can issue a written charge and requisition, or a person can be charged after being taken into custody without a warrant, or where a bill of indictment is preferred in certain circumstances. But those are the main examples. That's just for completeness.
Perry, just the general shape of your argument, if I understand it, is really to say that when Parliament creates offences, it does so without usually saying anything about who prosecutes it. It just does it against the general law of the land.
Yes.
And if you're in England, then that tells you that how you begin them in England. If it's a Scottish offence, it applies in Scotland. You just look at who starts proceedings in Scotland. And the only reason you have anything else in the Act is if you want to limit it or something like that. Is that's and exactly. You say that that's
exactly
limit or give special privilege.
Yes.
Privilege, exactly.
Yes.
Or control or something like that.
And that.
In the case of a corporation, well, in place of a private individual, in theory and subject to statutory limitations, a private individual can institute criminal proceedings on any subject whatever.
Yes. If it's an offence contrary to common law or a general public act.
Yes.
Yes.
Now, is the same position with corporations?
Well, my Lord, there may be limitations on the power of a corporation because you may be limited by your memorandum and articles of association because, of course,
that's really what I was.
Yes.
I was coming to.
Yes.
That the power of a corporation to institute criminal proceedings can be, and indeed perhaps must be, tempered by what is in the memorandum.
Yes, yes. And therefore, questions of vires may arise, but they don't in this case.
Yes, I mean, for example, with the Financial Services Authority trying to take a public law, have the power to prosecute somebody for treason. Nothing to do with money or anything else.
Well, my Lord, it may not be possible, it seems unlikely, but I wouldn't say on a priori grounds that you could necessarily exclude it, because, for example, it was suggested yesterday, what about murder? Well, suppose someone murdered someone who was employed in the FSA, or at the annual general meeting of the FSA. And suppose, I'm not suggesting that they're that
not
lively.
Perhaps an entirely unlikely circumstance.
Well, Lord, there is, in fact, I think it was in a decision decided before the House of Lords, I think it was in Humphreys, which concerned issue estoppel in criminal proceedings. It was within Viscount Dillon's memory in that case of private prosecutions being brought for murder. So,
yes. Yeah, but coming back to the FSA, and I gave you the example of treason, I was really thinking of an example where the alleged treason had nothing whatever to do with the FSA or its activities.
Well, in those circumstances, my Lord, it seems that there would be a real question of vires.
So there is a difference then between a position of a corporate body limited, or perhaps limited by its memorandum, and a private individual, because the treason might have nothing whatever to do with the private individual, or with the possible exception of the private individual's nationality, and perhaps not even that.
Yes. Although, my Lord, the controlling mechanisms for take this case where we're also dealing with a corporate body that is also a public authority. The controlling mechanisms would be ordinary public law principles, so that they would be subject to the controls of the courts, the supervisory jurisdiction of the courts, if they were to contravene any public law principle. And of course, they're also subject to the powers in their memorandum and articles of association. Now, it may be, my Lord, that the members of a corporate body would in fact give consent to a particular prosecution. And in fact, there were examples in the 19th century of bodies that were established to fund private prosecutions. James Stephen was funded to prosecute the governor of Jamaica by bodies that had been established to fund the prosecution. The well-known case of Governor Eyre. But there is no question in this case, and as I understand it, although my Lord Clerk put a question to my learned friend in relation to this, as I understand it, the appellant does not say that if his argument fails in relation to the construction of section 401 and 402, that there is any other impediment in relation to the Financial Services Authority's prosecution in this case.
You shied that fence this morning, I think.
How would it actually work? I mean, I'm just slightly puzzled. I mean, supposing that as I understand, somebody turns up, Mr. Parkinson turns up, and gets he puts in his information, and he gets his summons or whatever it is, or gets the summons. It's issued. I mean, yes. At that point, I mean, does the fact that could somebody say, well, it was beyond the powers of the company to prosecute for this particular offence? I mean, would that be enough to unscramble the proceedings? I mean, I just can't quite see how that works. I mean, once it's been issued, the summons has been issued, can he go back? What is his interest in saying that the company, it's beyond the company's? I mean, if the prosecution is a good one and taken up and so on, what does it matter if it happens to have been beyond the powers in the articles? Well, that's a matter for the members if they wish to complain about it. But I mean, what's it got to do?
My Lord, the position Lord, I know of cases, my Lord, where there have been challenges on the basis of vires at the point that the summons has been issued.
Is that in relation to a public corporate body or a private one?
The example I have in mind was a private corporate body.
And who challenged this?
I did, my Lord.
Not in your own right, I think.
Representing the defendant company. I was representing a company that was prosecuted by another company, and we, at the point of issue of the summons, took a vires point. And also it was a prosecution not under a general public act of Parliament, but a private act, but an act of limited application concerning licensing in a particular area, and we said that there was no power on the part of the company to prosecute.
And was your challenge at the point before the summons was issued?
We challenged at the issuing stage, my Lord. Yes.
Was it an abuse of process application? Or?
It was an appeal to the district judge's discretion, because he has a discretion on the basis that he should exercise his discretion. And later, we deployed an abuse of process argument. That was one of several submissions that were made in relation to the powers. But
does the proposed defendant get notice of the information before the summons is issued?
Not always, my lord. Sometimes there is notice. It may be, for example, within the discretion of the district judge. So, for example, thinking about the Israeli, some of the Israeli generals and representatives of the State of Israel who've travelled into London, who have sought advance notice of whether applications are going to be made for summonses in their cases, and the district judge has a discretion. Obviously, if someone's going to flee or on notice, he may exercise his discretion against disclosure. But if it is to enable legitimate inter partes argument on whether a warrant or someone should actually be issued, then he may think it's right to give advance notice. And
well, one might think there must be some method of permitting a proposed defendant to challenge the varies of the prosecution.
Yes. And, Lord, what you can do as well is, even if you don't have advance notice, you could go, when you do have notice, you could go back to court and ask the district judge to set aside.
Yeah.
So you could. That's another mechanism as well. So there is judicial.
If Mr. Parkinson, purporting to act for the FSA, went and put an information in for treason or murder, presumably it would be open to the FSA to withdraw the prosecution or withdraw the information.
Yes, my lord.
That's always available too.
Yes.
The process doesn't automatically continue till the end of a decision by a court.
Yes, but that's absolutely right, because any prosecutor has the power to withdraw a prosecution. I know in Scotland the Lord Advocate can even prevent a court proceeding to sentence. Has very wide power.
You may be interested to know, or may not, Mr. Berry, that one of the only two private prosecutions in the 20th century in Scotland was at the instance of a company. So there you are.
Well, my lord, I understand, and this may be relevant when we come to the Money Laundering Regulations 2003, that the commissioners for Customs and Excise have power to prosecute in Scotland, in addition to the Lord Advocate, and that may have some significance when we come to look at the Money Laundering Regulations 2003. But Lord, may I make a point in relation to the absurdity arguments, because the examples can be multiplied as to the absurdities that will result or may result, and which cannot have been intended by Parliament if the appellant's arguments are correct. For example, if during the course of an investigation carried out under the Financial Services Markets Act into offences created by that Act, the authority uncovered evidence of the commission of offences contrary to the Act and other offences, then, according to the appellant's argument, the case has got to be divided into two parts, with one part or handed over to the Director of Public Prosecutions in its entirety, with no guarantee, in fact, that the Director would, in fact, take over the conduct of the prosecution.
But he says, as I understand it, you can have a position whereby you have two prosecutors, you doing your statutory. And he says that used to happen in the context of customs prosecutions for, I can't remember now what.
I think, my lord, the submission was in relation to assigned matters which are within the jurisdiction of or used to be within the jurisdiction of the Customs and Excise Commissioners. Lord, what we submit in relation to that is, first of all, it is not conducive to efficiency or the effective use of court time or prosecutorial resources. And also, suppose the Director says, well, in fact, my resources for this year don't extend to prosecuting this sort of offence. I don't want to. There are too many murders in London at the moment. White-collar crime is not on my list of priorities, and I'm not going to. So the FSA have to give up part of a case, and a part of a case cannot be prosecuted. But there's an absurdity about it. The absurdity goes further, because if the FSA then went to a private individual and said, the Director's refused because he's got no resources this year to prosecute this offence, But we will, if you come in as a private individual, you could prosecute. And the private individual will say, well, what's in it for me? well, there's nothing in it for you except public duty and the eradication of white-collar crime. Well, we submit that that cannot have been intended by Parliament. It shows the absurdity. Acting through a single council is unpersuasive, and there is no good reason why the FSA, a body with specialised knowledge and expertise, should have to outsource the prosecution function to another overstretched public authority. Another example for which no good answer has been given arises from the conspiracy problem identified by the Court of Appeal. Without turning it up, it's Appendix Divider 5, page 100 of the bundle, paragraph 33 of the Court of Appeal decision. The problem is really reduced to its essentials this: conspiracy is not an offence under the Financial Services and Markets Act. Conspiracy is an offence under the Criminal Law Act 1977, or contrary to common law. So if there were to be evidence of a conspiracy to commit insider dealing offences or offences contrary to FISMA, then the authority would not have power to prosecute them, and we say that that is simply absurd. Other difficulties may also...
The answer that's suggested to that is that the offences which you clearly do have power to prosecute are worded in such a way as to cover all or virtually all cases that would otherwise be conspiracy.
Yeah. Well, my Lord, our short answer to that is they don't. Encouraging someone to commit an offence may or may not be a conspiracy. It may be a conspiracy if the person encouraged agrees to pursue a course of conduct that will result in the commission of an offence, but not necessarily. And suppose there are people who agree between themselves to encourage another person. That wouldn't be within the legislation. The offence of conspiracy would bring the potential liability of offenders to a much earlier point than the substantive offences contained in the Criminal Justice Act 1993. So we submit that there is no credible submission that can be made to say that encouraging is conspiracy. And just so that your lordships know, the authority has in fact instituted proceedings for conspiracy to commit, and successfully instituted proceedings for conspiracies to commit insider dealing offences. Lords, difficulties may also arise in the course of a trial, and this is the final example of the absurdities, because they can be multiplied. But just to give an example of the difficulties that may arise in the trial, which isn't met by the two-counsel solution. Suppose the prosecution evidence as adduced at the trial, in fact, discloses the commission of a non-FISMA offence. So you're prosecuting your FISMA offences, but the way the evidence actually comes out at the trial doesn't support the FISMA offence, but it does support an offence outside the Act. The prosecution counsel then applies to amend the indictment to include the offence which is now supported by the evidence, and the judge says, sorry, you do not have power to amend the indictment because you're acting on behalf of the FSA. It's just absurd to think that these situations could have been intended by Parliament. And in relation to this point, which is really just the theme that Parliament does not expressly endow powers of prosecution, your lordships may also gain some benefit from seeing what was said in the security industry case, to which reference has only been made in passing, but it's volume 2, divider 9 of the authorities bundle 2. And it's not necessary to look at the facts at all, but it was just the question in this case was whether the Security Industry Authority, which was a statutory body corporate, had power to prosecute, and the High Court, Lord Justice Morris Kay and Mr. Justice Blake, concluded that it did. But the helpful observations appear in the judgment of Mr. Justice Blake at paragraph 32 and 33. Paragraph 32 begins at page 258 of the report, but at the top of page 259, he said if there'd been a consistent and legislative practice to grant overt and unambiguous powers of prosecution to a regulator whenever this was intended, it may be that evidence of such a practice could be received in order to establish whether Parliament intended a different consequence in the words used in the particular statute under consideration. What was being argued in this case was that the Security Industry Authority didn't have power to prosecute, and that Parliament had a particular technique for saying when it had granted overt and unambiguous powers. And then in paragraph 33, and this is perhaps the important point, in the middle of the paragraph, Mr. Justice Blake said this: "It's hardly remarkable that Parliament should not have given the regulator overt powers of prosecution when a prosecution can be brought by the ordinary citizen in the public as well as in the private interest, see Ewing and Davis. In my judgment, the powers available to the private citizen also undermine the contention that in the modern era, only the Crown Prosecution Service or regulators, independent of the investigative process, can institute proceedings." So, Lord, that's really the point that we have sought to make.
I'm a bit lost. What was going on there? What were these claimants trying to do?
Lord, that was a prosecution under the Security Industry Act.
Yes.
And the Security Industry Act, your Lordships will see from paragraph 1 of Lord Justice Morris Kay's judgment, the Security Industry Authority is a body corporate, and it had power to do anything it considered is calculated to facilitate or is incidental or conducive to the carrying out of its functions. So the claimants were saying, although it's got those powers, it does not have the power to institute criminal proceedings because Parliament has not expressly provided that it may prosecute. And Lord Justice Morris Kay dealt with the power to prosecute between paragraphs 10 and 18, and it really was that because the authority could do anything incidental to its ordinary functions, then it could also bring criminal proceedings ancillary to its fulfilment of those functions or in support of those functions. And Lord Justice Morris Kay relied on the authorities upon which we also rely. For example, paragraph 14, where he's at page 254 of the bundle, 4 lines down from the bottom of paragraph 14, the Security Industry Authority is in a peculiarly advantageous position to prosecute, which is the same here. To borrow the words of Lord Wolfe, Chief Justice, and the Queen on the application of Hunt and the Criminal Cases Review Commission, where he was considering the position of the Inland Revenue. Then Lord Wolfe, as Master of the Rolls in the Broadmoor Special Health Authority case about public bodies bringing proceedings when carrying out their functions. And he goes on to deal with the fact that the power to prosecute simply existed in accordance with the powers of the authority. And that's also the point that's being made by Mr. Justice Blake in paragraphs 32 and 33. And, Lord, may I just before turning to section 401 and 402, just make another important point so that your lordships have it in mind. And it's a point which addresses the so-called symmetry argument, namely that the FSA cannot have a power to prosecute because there would be an asymmetrical position between its powers of investigation and its power to seek injunctions. Lords, I will demonstrate in a moment, if I may, that in fact the FSA does have power to conduct money laundering investigations. But it's not to be found in the Financial Services and Markets Act. It's to be found in powers given to the FSA under the Proceeds of Crime Act. And your lordships have not been referred to those powers. But what I will demonstrate, I hope, by reference to those provisions, is that the authority can, in fact, conduct investigations into whether offences contrary to 327, 328 and 329 of the Proceeds of Crime Act have in fact been committed. So far from there being no powers of investigation, there are express powers of investigation. But what that means on the appellant's argument is Parliament has provided the power to investigate, but you cannot prosecute, which is another absurdity. And we say again that cannot have been intended. So, my Lord, may I just go to...
So their argument in turn leads to a non-symmetry.
Yes. And also, my Lord, another...
Thank you.
and also, my Lord, another absurdity. So they've got the power to investigate. They've even got the power to get warrants and enter premises to obtain evidence of money laundering. But presumably, once they have gone to the trouble and expense of getting the warrant and getting all the evidence, they have to say to the Director of Public Prosecutions, over to you. And then the Director of Public...
That goes a little bit too far, Mr. Perry, because that's exactly what they have to do if it's in Scotland. That's exactly, they have to hand it all over to the Procurator Fiscal and the Lord Advocate to prosecute, because they can't prosecute.
Yes.
So, I mean, it's a limit to that argument.
Well, yes. Well, my Lord, my Lord, I can at least, for the weight that it has, my Lord, in England and Wales.
Yes, I see the point, of course.
Yes.
But all I'm saying is one can just push it.
But well, no, Lord,
it's better to refute the symmetry argument than it is to establish a freestanding absurdity argument.
Yeah. Well, but my Lord, may I then just use it to refute the symmetry argument? And
but accepting that the position in Scotland is absurd.
Lord, I'd reserve that submission for when we're dealing with the devolution issue in the Privy Council. But, my Lord, may I just turn to section 401 and 402 of the Financial Services Act, Financial Services and Markets Act, just so that your lordships
Just before you do that, could you just give us the reference to the sections in poker?
My Lord, I'm going to come to them, but...
I think you said 327, 328.
Those are the offences, my Lord, yes. But the actual provisions, the important legislation, Lord, is actually a statutory instrument, which is Volume 1, Divider 24, which is... references to Financial Investigators Order, but I'm going to deal with that in due course, if I may, my Lord, and just explain how it fits together.
I mean, I suppose it might be said against you that all of these post-date the 2000 Act, and we are concerned with interpreting the 2000 Act at the time that it was enacted.
Well, Lord, that was the point made against us in relation to the Banking Act, Lord, but what we submit in response to that is when Parliament's making these orders or amending legislation, it knows the very context in which it's operating and it knows what the earlier legislation achieved. Now, what we submit is when Parliament, for example, says the FSA may be an investigator for money laundering offences, and it's an accredited financial investigator. Parliament is doing that in the knowledge we submit that not only has it got powers to investigate, but it's got powers to prosecute. So, Lord, we submit it's all of a piece.
But I'm sorry, I thought you were relying on powers to investigate money laundering in POCA, which is,
Yes.
doesn't that post-date?
Yes. Yes.
And therefore, it's not a big point perhaps, but I mean, if we're looking at the symmetry argument as an aid to construing what Parliament intended in the 2000 Act, I'm just suggesting that the fact that that investigatory powers were given in a later statute it may not be of much significance.
I think what you would say is that it provides an insight into what Parliament had intended.
Yes.
Because if the earlier legislation had not provided those, had created a code, well, then there would be no point in investing them with investigatory powers.
Exactly. What the later legislation does not say is you have power to investigate and prosecute. It says you have power to investigate. The unstated assumption is you have power to prosecute. And we submit that the unstated assumption is what underlies all the legislation going back well before the Financial Services and Markets Act. But I'll deal with that in a moment, Lord, if I may, when I come to the particular...
I mean, both sides are contending for unstated assumptions. You, that there is a power. The other side, that there isn't a power of prosecution.
Well, Lord, we would submit that if you're going to take away a power that is recognised as an important power, recognised in statute, you'd have to have express words in order to do that. But, my Lord, just dealing...
You say that all statutes proceed on the unstated assumption that everybody has a power to prosecute.
Yes, my Lord. And then what you have then is either the limitation or the privilege.
So we're back to whether, on the true construction of sections 401 and 402, construed in the context of the Act as a whole, having regard to the statutory purpose, excludes that right.
Yes. That's exactly it, my Lord. And just so that your Lordships know what we say in relation to section 401, our submissions in relation to 401 are that the essential purpose of section 401 is not to confer on the Financial Services Authority a power to prosecute. The purpose of section 401 is to limit the persons who may institute criminal proceedings for offences under the Act or subordinate legislation made under the Act. And we submit that that is made clear by the inclusion within section 401 subsection 2, which is the provision governing England and Wales, of the express reference to the Director of Public Prosecution. So that makes it clear. You wouldn't need to refer to the Director if you were conferring powers of prosecution. And similarly, in relation to Northern Ireland, the Director of Public Prosecutions in Northern Ireland. And then except in Scotland, because, of course, it's dealing with England and Wales, but it's proceeding on the basis that...
And is that because the DPP has a separate statutory power to prosecute? Or does he prosecute... well, on what basis does the DPP prosecute?
Lord, there isn't anything in the Prosecution of Offences Act 1985 that confers a power to prosecute on the Director. What the 1985 Act says is the Director is to have the conduct of certain prosecutions. It doesn't say the Director is empowered to prosecute these offences. Otherwise, you'd have to have a very long list, and you'd have to keep it up to date all the time, and you'd get into the same sort of difficulties that we had in extradition, when you could only extradite for lists of offences, and if you weren't within the list. So Parliament never proceeds on the basis of a list of offences, saying the Director can prosecute a list. What the 85 Act says is it's the Director's duty to have the conduct of certain proceedings.
So you're saying again, it's implicit in the legislation, or
yes,
statutorily assumed, that the Director can prosecute in every case.
Yes, yes.
Does he do that just by virtue of being an individual?
Yes, yes. But of course he has special powers, and so too do Crown prosecutors.
But not special powers of instituting, is that right?
No. And then...
But with the consent part implies that there are other people who can prosecute, but only with the consent of the
Yes.
legislature.
So that's
the point.
That's the point, and it's the filtering point, Lord. This acts as a protection, in effect, so that anyone can prosecute these offences so long as they've got the consent of the director. But the director is exercising control of access to the criminal courts in relation to offences which may have a degree of sensitivity or require an expertise to prosecute. So, and the same point can be made, I've already made the point in relation to Northern Ireland, but 4, we submit, is also important because it's also, 4 is making it clear that except in Scotland, proceedings for an offence under section 203 may also be instituted by the Office of Fair Trading. Now, section 203 is the provision that makes criminal, or is an offence-creating provision in relation to Consumer Credit Act business matters. It's not necessary to go to it, but it's in relation to a matter in respect of which the Office of Fair Trading may be considered to have a special expertise. Now, we know, because we've seen it in other legislation, that the Office of Fair Trading have powers of prosecution outside section 401. So all that 401(4) is achieving is saying within the limited class of people who may prosecute is also the Office of Fair Trading. But that doesn't, of course, apply to Scotland.
I mean, what it does, unless I misunderstand, is not to give power of prosecution. It really adds it back in, having been taken out by 2 and 3. It then puts it back in again, isn't that right? Because if you stopped at 2 and 3, then that would take it out.
Yes.
And therefore, even if at common law it could prosecute, it couldn't do it. So it puts it back in by 4.
Exactly, my lord. And what the Office of Fair Trading, or the Director General of Fair Trading, as the Act was in its original form would have needed to do, would be to go and get the consent of the director to prosecute. But Lord, this demonstrates the danger of relying on explanatory notes to legislation, because if your lordships look at paragraph 710 of the explanatory notes, which actually is in the main bundle behind divider 10 at page 113, it completely misstates the effect of section 401. Well, that may, perhaps that's overstating, but at 710, paragraph 710 of the explanatory notes at page 113 of this bundle, it says this section confers powers to prosecute offences under the Act. What in fact it's doing is limiting the ability of individuals, other than those named, within section 401 to institute proceedings. And just so that your lordships know, on this aspect of the case, we submit that the Court of Appeal reasoning in relation to section 401 is absolutely correct and unimpeachable, and to cross-reference, see divider 5 of the appendix, page 97, at paragraph 23, and we submit that paragraph 23 of the Court of Appeal decision is entirely correct in its analysis of section 401. My lords, in relation to section 402, this
can best be explained in this way. So far as 421A is concerned, that is a dispensing provision, inasmuch as it dispenses with the need for the authority to obtain the consent of the Director of Public Prosecutions or the Secretary of State that would ordinarily be an obstacle to the institution of proceedings. And the 4021A simply dispenses with that. And just so that your lordships know what our position is in relation to the Uberoy decision, we say that Uberoy was correctly decided, but we say the reasoning was incorrect. It was not necessary to say that the dispensation is a matter of implication.
It's a matter of what?
Of implication, my lord. We submit that if the position was, as we submit it was, before December 2001, that the FSA could have prosecuted with consent for insider dealing offences, as clearly it could, then for Parliament to have said the authority may institute proceedings for an offence under Part 5 of the Criminal Justice Act would have been telling us no more than what we already knew if it was subject to consent. So it must be that it's just dispensing with the requirement for consent. But you don't need to you don't need to say there's a distinction between instituting proceedings and getting consent and undertaking the analysis in Uberoy. We submit that the result in Uberoy was correct, but the reasoning was not. And then 4021B, this is...
Just before we pass to B, I mean, because eventually you're going to be saying, I think B and C, in part are explained, or perhaps wholly explained by, because they then enable the Treasury to put these conditions or restrictions on. I mean, what about that being an explanation for A? I mean, assume that Uberoy was wrong. In other words, that it wasn't somehow, just assume it. I mean, could it be then said that the reason 4021A is there is again so that the authority can be required to submit to conditions or restrictions imposed by the Treasury?
Well, my Lord, yes. My Lord, that certainly that may be.
So if Uberoy had, so to speak, looked at B and C and not merely at A, I mean, just conceivably they could have reached that conclusion.
Yes, yeah, I fully accept that, Lord. But to say that expressly the authority may institute proceedings under Part 5 and then say that still requires that Parliament intended there to be the obtaining of consent, we submit doesn't give sufficient weight to, once you're saying expressly may institute proceedings, you don't need consent. And then 4021B, Lord, prescribed regulations relating to money laundering. This is, again, we would submit, looking to prescribed regulations where there may be a limited class of prosecutor, as there now is under the 2007 money laundering regulations, and as it appears was the position also under the 2003 regulations. And then...
Are the 2003 ones the ones that are referred to but we haven't seen?
Yes, and I've got them, my Lord, and I'm going to take your lordships. Yes, they've been handed up already, I understand, Lord, but I'm going to come to those, Lord, if I may.
Sorry, Mr. Perry, I've got the 2003 regulations. I missed the other reference.
The 2007 regulations, my Lord. It's the 2007 and the 2003 regulations, my Lord, which appear to have the charmed circle of prosecutors the limited class of prosecutors.
I mean, you would say it's a pretty irrelevant error, but the Court of Appeal did make that error, didn't they? In
Yes.
Paragraph 24.
Yes, and, my Lord, we do accept that, my Lord. In defence of the Court of Appeal, it's a rather technical area, but if you just simply delete with consent of the Director of Public Prosecutions, it doesn't make any material difference to their conclusions. They were making it clear that this was identifying specialist prosecutors without the need for the authority to go elsewhere.
So I don't think I've quite understood. What do you say the purpose of B is, Mr. Perry?
B and C, my Lord, they're both specialist prosecutor provisions. So when we come to look at the regulations...
So why are they specialist and insider dealings not specialist?
Sorry, my Lord. B and C is the limitation of the class of prosecutor provision, my Lord.
You've lost me at the moment.
I'm very sorry.
It's my fault.
I'm very sorry, my Lord. Your Lordship is absolutely right. Insider dealing is usually reserved to the DPP, the Secretary of State, or the FSA. But the prescribed the prescribed regulations, now into the 2007 regulations, limit the ability of anyone to prosecute to identified prosecutors. So in a way, it is running in parallel with the insider dealing. These are the specialist prosecutors, but it's just defining the class of prosecutor. But that's in the prescribed regulations. And similarly...
So supposing that B weren't there, but the regulations existed, so what would the effect be?
Well, my Lord, the effect, I suppose, would be twofold. First of all, you would have money laundering regulations, if they weren't prescribed for this section, which Parliament could identify the prosecutor, could limit the prosecutor, but then you wouldn't be subject to subsection 2 of 402, which is the conditions or restrictions.
So we come down to that, really. It comes back to that.
Well, yes. Yeah, but they would be. Your Lordship is absolutely right, and Lord, it may also be that there's another matter in relation to the Treasury, because many of the offences, I'll take your Lordships to them in a moment if I may, but just to explain so that your Lordships know. In the offences under, take the 2007 money laundering regulations, for example. When you institute, or when a court is deciding whether someone is guilty of an offence under those regulations, it must take into account the extent to which the person has complied with guidance approved by the Treasury. So the Treasury is playing quite an important role in whether an offence is committed. So the Treasury may be a little sensitive if you're going to be prosecuting and it's going to turn out that someone says, well, I'm not guilty because, look, I complied with what the Treasury told me to do. So that may be why, or it's at least one possible rationale for why the Treasury have a particular interest in these proceedings. And thank you. And I'll come on to deal with that in a moment, if I may. But,
Mr. Perry, I'm sorry, I'm being slow. If 402(1)(b) were not present, then there would be a small group of people who would be entitled to prosecute for money laundering offences. Is that right?
Under the 2007 regulations,
yes,
that's
which
right.
would, for this purpose, not include the authority. And what subsection, yes. What paragraph B does is to include the authority within the charmed circle.
Yes.
Right, thank you.
Yes. But, my Lord, the point that was being made either for or against me was if B were not there and you simply had money laundering regulations that did in fact refer to the authority, what does B add to the regulations which could be freestanding? And my response to that is, well, you still have subsection 2 and the keen interest that the Treasury has in prosecutions under money laundering regulations and terrorist financing.
Thank you.
So, Lord, what we submit is that our interpretation of section 401 and 402 is coherent and also provides an explanation as to why the sections are structured as they are. It may be, as the Court of Appeal said when it considered the 1993 money laundering regulations, which did not have the limited class of prosecutors identified, that the position is a little untidy. But that may also be explained on the basis that the provision is looking prospectively, and it was expected that there would be a limited class of prosecutors, or at the very least, even if there were not, that the position would be subject to Treasury control. But whatever the position in relation to the untidiness or the wrinkles, they cannot detract from the point that section 402 cannot provide an exhaustive statement of the authority's prosecutorial powers. This is because the power to institute proceedings is also to be found in other legislation. And if I may just take your lordships to that other legislation, Volume 1, Divider 1 of the bundles contains the Industrial and Provident Societies Act, and the power to institute proceedings is, under the Act, is contained in section 66, which is on page 2 of the bundle. And again, this is an example of Parliament proceeding on the assumption that the authority and others, for that matter, may prosecute, because there's nothing in the Industrial and Provident Societies Act 1965 which expressly confers a power to prosecute. But your lordships will see that under section 66, proceedings for the recovery of a fine, all that means that under this Act, if you were prosecuting someone, it's treated as a recovery of a fine because the offences are only punishable with fines. Your lordships will see that in section 64 and section 65, where in section 64 there's a reference to level 2 on the standard scale, which is a fine of £500. And in section 65, there's a reference to level 3 on the standard scale at the very end of section 65, £1,000. So if you're proceeding for a recovery of a fine under the Act, which is recoverable on the summary conviction of the offender, proceedings may be instituted by the following persons. That is to say, A, in the case of proceedings by virtue of section 64, which is the fraud or misappropriation provision, by the registered society concerned, or 2, any member of that society authorised by the society or its committee or by the authority, which is the Financial Services Authority. 3, other than in Scotland, the authority. B, in the case of proceedings by virtue of section 13, subsection 3. Section 13, subsection 3 is not in the bundle, but it's a fine imposed by the rules of a society registered is recoverable under the Act as on conviction for being in breach of the rules. So in the case of proceedings by virtue of section 13, subsection 3, the registered society concerned, and C, in any other case, so any other fine, any person aggrieved, or two, other than in Scotland, the authority, and except in Scotland...
So should that be in square brackets? Oh, it is in square brackets, I think. Yeah.
Yes. And then, my Lord, and except in Scotland, no other person may institute proceedings. So this is an example of where you're identifying the prosecutors and making it clear that no other person may institute proceedings. So there must be an assumption that but for that, anyone could institute proceedings, but you've limited it. So there's an example. But the significance of this provision is that the FSA clearly does have power to prosecute for offences outside the Financial Services and Markets Act. And, my Lord, may I just make another point in relation to the deeming provision argument, just so that your Lordships know what the position is in relation to that. When we come on to look at the deeming provision argument, the argument being, well, this is all deemed to be under the Financial Services Markets Act anyway, your Lordships will see from the Mutual Society's order that the prosecutorial powers are not deemed for the purposes of the deeming provisions. They exist under the earlier legislation. So we make that point also. And of course, the deeming provision doesn't answer our point in relation to the payment services regulations. And then the other...
Can I just ask you about subsection 1?
Yes.
Here, though.
Sorry.
It previously said what before it said the authority?
It was the Commission. We see that from the Mutual Societies order. If your Lordships go to our supplementary bundle, and we've got this Financial Services and Markets Act 2000 Mutual Societies order, and your Lordships will recall that the appellant made reference to this yesterday, because the point that is being made here is that under this order, by reference to Article 4, which is on page 2, certain functions were transferred first to the Treasury, that's Article 4, 1A, B and C, and then Article 4, paragraph 2 is the functions which go to the FSA, and that's the Chief Registrar, Friendly Societies Commission and the Building Societies Commission, and they were the bodies. Yes. Yes, and Mr. Grudinsky helpfully refers to page 91 of this order, which deals with amendments to the Industrial Providence Societies Act, where at page 91 we've got paragraph 215, for the words appropriate registrar, registrar, chief registrar and central office, insert authority. And if your Lordship's going to page 96 of this extract is where section 66 then appears as we've got it in divider 1 of our bundle. So, my Lord, that's where it
But on your case, the authority would have been entitled to institute these proceedings quite apart from this section, would they? At common law.
Subject to any limitation, such as the one that appears in the Criminal Justice Act 2003, saying that no person may institute proceedings.
What kind of proceedings are these, Mr. Berry? Proceedings for recovery of a fine. What are they?
They're criminal proceedings, Lord, because it's a rather curious way that they've dealt with it. But if your Lordship see the proceedings for the recovery of fine, which under this Act is recoverable on the summary conviction of the offender. Yeah. So it's a summary conviction.
No, he's been convicted. I mean, what? I mean, he's been. I don't quite follow it. I mean, he's been convicted. He's fined, and then it tells you who can bring proceedings. I mean, I would imagine the fine would land up in the usual way in the consolidated fund, wouldn't it?
Yes.
I mean, it doesn't. I mean, I just don't know. It doesn't look to me as though you're starting criminal proceedings. You're starting criminal proceedings. I mean, the point is, subsection 2 bears you out, of course, entirely, as far as I can see. But subsection 1 looks to me as 16 is slightly different, something slightly different. I don't know.
Well, would we be better informed if we'd got section 64 available? We have section 64. I'm sorry.
Section
13.3. Would it make any difference to our understanding of it?
Well, my Lord, I have been through all of this, my Lord, to make sure that there's nothing that we should be placing before your Lordships. I was very anxious to ensure that your Lordships had all the
proceedings,
the right material. But it's in the Financial Services Act, volume 19.1.
Mr. Perry, please don't worry about it. I think
I'm sorry I asked the question.
I'm diverted.
I can't believe this is the most important point.
No, it's subsection.
I'm sorry I asked the
subsection 2.
Subsection 2 carries.
Yes. My Lord, section 3, I can tell you what, I can have it copied.
If you do, please don't stop anybody developing the argument for now.
Yes.
It's lunchtime would do for me. But as my Lord says, subsection 2 is something we've already familiar with.
Yes, my Lord, mercifully, subsection 3 is very short, and it does support the point made by my Lord Roger, because it says, any fine imposed by the rules of a registered society shall be recoverable on the summary conviction of the offender.
Well, are you not better off by focusing on section 66, subsection 2?
Yes. So subsection 2, notwithstanding any limitation on the time for the taking of proceedings contained in any act, any proceedings such are mentioned in subsection 1, which are instituted by the authority or by the Lord Advocate, may be brought at any time within 1 year, so, but not more than 3 years. So it's the same point as we've made earlier, and that's
the same point as in the Building Societies Act.
Yes, exactly, my Lord, and that's divided. The Building Societies Act is Volume 1, Divider 4. Then we've also got the Friendly Societies Act, Volume 1, Divider 6, which is another time limit for commencing prosecutions.
So you're put in a privileged position in regard to the time provision. Is that in respect of all three?
That's exactly it, my Lord. And but the assumption in each case is that that the authority is a prosecutor, and then we've got the payment services regulations, to which I've already made reference in this volume at Divider 22, Regulation 117. So. Lords, may I just very briefly deal with the legislative position prior to the Financial Services and Markets Act to address a point that was raised yesterday by my Lord Sir John Dyson in relation to the ability of the authority to prosecute before the Financial Services and Markets Act came into force. And so that your Lordships know what our position is, we submit that the position up until the coming into force of the Financial Services Markets Act was clearly the authority as a corporate entity with legal personality could institute criminal proceedings, and in fact it had inherited certain prosecutorial functions that had previously been carried out by the Bank of England, and that can be seen by the Banking Act 1987, Volume 1, Divider 5. And the Banking Act 1987 was a statutory scheme that recognised that the Bank of England was a prosecutor, and that can be seen in Volume 1, Divider 5 at page 25 of the bundle.
We saw this yesterday.
Yes. But just so that your lordships know, the bank, historically the position was, my lord, that the Bank of England, for example, did not confine its prosecutorial powers to offences under the banking legislation. For example, it was commonly the case that the Bank of England would prosecute for offences of theft, which are not offences under the Banking Act. The Bank of England would frequently prosecute offences of forgery, not offences under the Banking Act. What this is doing is saying under the Act the prosecutors are principally the director or the bank or with their consent. And then the Bank of England Act 1998, Volume 1, Divider 8 of this
I'm curious, I'm not sure. I mean, what's the relevance of telling us that the Bank of England is prosecuted for theft and forgery?
But, my lord, it's really, my lord, just to make the point, in 96.5, when it's saying no proceedings for an offence under this Act shall be instituted, it's recognising that, again, you're having a controlling mechanism as to who can institute proceedings under the Act. What you're not saying is that the Bank of England can only prosecute offences under this Act. And then under the Bank of England Act 1998, the functions of the bank, which included its prosecutorial functions under the Banking Act 1987, were transferred to the authority, and that can be seen behind Divider 8 at page 34 of the bundle, section 21 of the Bank of England Act 1998. The following functions of the bank are hereby transferred to...
I'm sorry, which page again?
I'm sorry, my lord, it's page 34.
34, thank you.
And it's section 21 of the 1998 Act, my lord, which deals with the transfer of functions from the bank to the authority, its functions under the Banking Act 1987, which we've just looked at, which was Divider 5, which were certain prosecutorial functions, but it's not saying you can only prosecute for limited number of offences. For example, under the Banking Act, if you had offences committed under that Act, but theft or forgery or fraud, then the FSA would have been in a position to prosecute.
This function, as you say, transfers certain prosecutorial functions under the Banking Act in 1987. But to take the example you gave earlier on of theft, it wouldn't have been transferred.
No, but...
Is that right?
That's right, my lord, because it would need to be, because that just exists anyway. But what Parliament cannot... The point really, my lord, is this. What Parliament cannot have intended is if the bank had prosecuted under the earlier legislation and it had evidence of theft and a Banking Act offence, Parliament, when it was enacting this legislation, was not seeking to take away powers to prosecute. And it would be implausible to suggest that Parliament was suggesting that the financial services sector should not be subject to supervision and, if necessary, rigorous prosecution by the regulator.
Section 21, what does that provide?
But, my Lord, it's just the transfer of functions to the FSA, my Lord, from the Bank of England.
What functions?
Including, that would include, my Lord, the power to limit prosecutions. So it can prosecute under the Banking Act 1987. It becomes the privileged prosecutor rather than the bank. So whereas...
We get that out of section 100.
If we go back to divider 5, the way that it would work is under section 96(5), where it says proceedings for offences under the Act shall be instituted, no proceedings shall be instituted except or by or with the consent of the director or the bank. It will be the director or the FSA. So that's the way it operates.
So the FSA can give consent for somebody else to do it?
Yeah. So it'd be pretty odd if they could give...
Sorry, I just don't quite see how that follows. The bit of section 21 we've got simply says the following functions of the bank are hereby transferred to the authority. Its functions under section 104 of the Building Society. Then in brackets, banking supervision. Have I got that wrong? Page 37.
Page 34.
Sorry, I'm looking at it wrong.
I'm sorry, my Lord. It's 21A, little Roman 1.
I beg your pardon. I was looking at page 37.
I'm sorry, my Lord. That's... And then... So that's the way that operates.
Sorry.
And then without going to the Financial Service Act 1986, which is Volume 1, Divider 3, and the delegation Volume 1 Order, Volume 1 Divider 16, our submissions in relation to that, those are the provisions to which your Lordships had extensive argument yesterday and this morning. We submit that they are simply all of a piece with the position for which we contend, namely, there is an example of legislation imposing a limit on the ability to institute criminal proceedings by reserving the prosecution to certain individuals or bodies, but what the 1986 Act does not do, nor does the delegation order, is provide an exhaustive code of the offences which may be prosecuted.
What the order does is, as I understand it, to transfer the Secretary of State's function of instituting proceedings to the whatever it's called, the delegated authority. Is that right?
Yeah, that's right, my Lord. But what it's not saying, my Lord, is that the authority...
agency. Sorry.
Yes. That's right, my Lord.
So it becomes, in effect, it takes over the functions of the Secretary of State. Is that right?
Yes. And I
is that wrong? So I may be
no,
wrong.
no, your Lordship's right. And they're actually functions which are conferred on the authority, but the Secretary of State can also exercise the functions. It's made clear that he reserves to himself.
Yeah.
So what you've effectively done is enlarge the class of prosecutors, but what the delegation order is not doing is saying you, the authority, may only prosecute this list of offences. And it would be very odd if Parliament were to do that. So, my Lord, in the next 5 minutes, may I just set out the essential steps in our arguments, my Lord, which follow from our submissions up to this point. Our submission, first of all, is that the Financial Services and Markets Act proceeded on the basis that the Financial Services Authority was an existing corporate entity with legal personality and as such enjoyed the ability to institute proceedings, whether civil or criminal, and the Act is to be read on that basis. Secondly, Section 1 of the Act, Section 1, subsection 1 of the Act, does not state that the authority's functions are to be limited to those conferred on it by or under the Act. It's proceeding on the basis that the authority exists, and in its corporate form, it's having functions conferred upon it, but clearly the authority as a corporate entity will be able to do other things other than simply carry out the functions under the Act. The third point is Section 1, subsection 4 of the Act refers to functions whether generally or under this Act. And as the Court of Appeal noted, that wording plainly contemplates that the authority has wider functions than those under the Act. On this, if I may just give your lordships the reference, the Court of Appeal dealt with this at paragraph 20 of their judgment, with which we agree without reservation. See appendix page 20, or paragraph 20, sorry, and I may have I'll check the page reference. The fourth point is the position under the Financial Services and Markets Act is made clear by paragraph 17 of Schedule 1 to the Financial Services and Markets Act, which acknowledges that the Financial Services Authority may be acting for incidental purposes. We deal with this in our printed case, where we set out paragraph 17 at paragraph, cross-refer to our printed case.
Paragraph what?
Paragraph 18 of our printed case, my lord,
Yeah.
at page 69 of the appendix. And the fifth point in the steps in our argument is that the memorandum and the articles of association of the authority are broadly and flexibly drafted and clearly permit the authority to act, to do anything that the authority considers incidental, desirable, or expedient, or to assist or enable it to carry out its powers. And this is really dealt with by the Court of Appeal at paragraph 6 and 7 of their judgment. See the appendix divider 5, page 92, just for your lordship's note. And lords, the memorandum and articles of association, we've put them in their from 2000, we've put them in our supplementary bundle. The April 2000 divider 2, without going to them, they're dealt with by the Court of Appeal. Then the amendment, the February Amendment 2001 is divider 3, which of course was in anticipation of the coming into force of the Financial Services and Markets Act. And then there's also the Memorandum of Association dated the 6th of February 2006, divider 3. So I hope it deals with it. My Lord, what I've got left to deal with, my Lord, which I hope I can deal with crisply, is the Proceeds of Crime Act investigation point. I've got something to do on the deeming provision point, but my Lords, and some points from the oral submissions, but my Lords, I hope I'll be in a position to finish in about 30 or 40 minutes of this afternoon's session, if that's suitable for your Lordship.
Well, thank you very much. It sounds to me, if it's convenient to you, that this is a moment we could rise until 2 o'clock.
Thank you very much. Thank you.